Outline the procedure for removal of company director from office. Procedure for removal of a company director from office. Who's going to go first? It's your chance to attempt. Case says an ordinary resolution is to be passed to remove the director. Good. So it has to begin with notice. Notice. So you are right, candidates. Notice. And what is this notice? It is notice of the intention to remove the director. Notice of intention. Notice of intention to remove the director. But you cannot just stop at that, candidates. Who issues such a notice? Who is eligible to give a notice to remove a director? You have to state. Don't just say notice. Where should this notice originate from? Talk to me. Before you go to ordinary resolutions, let's deal with the notice. It is notice of intention to remove the director. Shareholders. Shareholders. That is to say that a shareholder, so I've put an S here in bracket, or a group of shareholders. It can be a single shareholder or a group of shareholders who holds at least 10% of the voting rights. Holding at least 10% of voting rights. It's not just anyone who can give notice of removal of at least 10% of the voting rights. Such a person can give a special notice to the company of the intention to propose a resolution to remove a director at the next general meeting. Candidates, procedure. We are discussing the procedure. It is not like some of you are stating that a notice will be given, then a meeting will be called, then a director will be removed. No, there has to be notice of intention to remove, and not anyone can just give this notice. It has to emanate from a shareholder or a group of shareholders holding at least 10% of voting rights. Such can give a special notice to the company of their intention to propose. So they are just proposing to have a resolution to remove a director at the next general meeting. So is it only the shareholders who can do that, give a notice? I had asked a question, who can give this, who gives this notice of intention to remove? You've said shareholders, which is true. debenture holders. Debenture holders. Bernard, you are allowed to guess. This is the right time to guess, but don't guess in the exam room. Make sure you have the facts. Debenture holders. Can debenture holders propose? Debenture holders who are not owners, can they remove a director of whom they didn't appoint? Come on, somebody. Company secretary. Court is an arbiter. A court only resolves disputes. But here we are talking about management of a company. We are discussing management of company affairs. Courts only come in to act as arbitrators. Board of directors. Board of directors. Board of directors. Board of directors. The board can also propose a resolution to remove a director. However, they must give the director in question special notice of the resolution and the reasons for it. You understand? The reasons. Then in the procedure candidates, we have the director's right. This is number one. Director's right to be heard. And this director may be heard in person, or the director may be heard through a representative. You understand? The director proposed for removal has the right to make written representations to the company and to be heard at the general meeting, either in person or through a representative. So before that happens, the director can write his response in writing. He has a right to be heard. It's not a must. It's a right which he can exercise or not. So he may come over to the general meeting and make oral presentations to defend himself or say whatever he wants to say in that meeting. General meeting. General meeting. Procedure. You see how it is flowing, candidates? Procedure. There is a notice of intention. The director has a right to be heard through written representations or to come to the meeting. General meeting. The resolution to remove the director must be passed by an ordinary resolution at the general meeting. Okay? Ordinary resolution at the general meeting. You understand? After the company receives the notice of intention from the shareholders or board of directors, and after the director has been granted his right to be heard or to make his written representation, then a general meeting is called where an ordinary resolution is passed. The resolution to remove the person through the resolution that is to remove the director must be passed by an ordinary resolution at the general meeting. That is to mean just simple majority of the votes. Simple majority of votes cast by shareholders who are entitled to vote. Then after the resolution, there is notification that has to be made to the registrar. The registrar has to be notified. notification to the registrar of companies. The company must notify the registrar of companies of the director's removal within 14 days of the resolution. The resolution to remove the director. It has to be within 14 days. Procedure, candidates, procedure. So when answering, you have to remember the timelines. Notification to the registrar of the intention to remove the director after a resolution is passed, a simple majority of the votes at the general meeting. Notification to the registrar. You understand? But of course, there could be additional things that have to be considered in removing a director, one of which is in relation to the Articles of Association. The Articles of Association may contain additional provisions or requirements relating to the removal of the director. You understand? Apart from the procedure we've outlined, when removing a director, it's important to check if there are any provisions relating to additional requirements relating to the removal of a director from office. You understand? Other matters to consider will be employment contract. If the director has an employment contract with the company, then the terms of the contract will have to be considered. Then, of course, there is the issue of compensation. The director may be entitled to compensation or even damages if their removal is in breach of their contract or in breach of the Company Act, Companies Act. So generally, candidates, that's the procedure for removal of a company director. 7 marks.